Right, let's dive into what is honestly one of the most counterintuitive but totally fascinating areas of property and tort law. Have you ever wondered what happens when someone breaks the rules, enters your property without permission, and then gets hurt? Picture this. Someone actually sneaks onto your land, breaks your rules, gets injured by something on the property, and then turns around and tries to sue you. I mean, logically, you just tell them, hey, you shouldn't have been there in the first place, right? Well, surprisingly enough, under the Occupiers Liability Act 1984, the law might actually be on their side. That's right, property owners can, under very specific circumstances, owe a statutory duty of care, even to people who are completely uninvited. So, in today's explainer, here's what we're going to cover. First, the trespasser injury paradox. Second, the duty of common humanity. Third, the three-part duty test. Fourth, the limits regarding obvious dangers. Fifth, defenses for the occupier. And finally, the bottom line. Part 1. The trespasser injury paradox. Now, legally speaking, a trespasser isn't just, a cat burglar sneaking around in the dead of night. It's simply any visitor who has no permission or authority to be on the occupier's land. That could be someone taking a quick shortcut across a private field, or even a customer who just wanders through a door clearly marked staff only. Moving on to Part 2, a duty of common humanity. Historically, the law here was incredibly unforgiving. Back in 1929, this was the Addy versus Dumbrick case. The law owed basically zero duty to a trespasser, not even to a 4-year-old child who was tragically killed on colliery land. It was harsh. But fast forward to 1972, and the House of Lords drastically shifted gears in British Rail Board versus Herrington. In that case, a 6-year-old was badly burnt on an electrified railway, and the court introduced this idea of a duty of common humanity. Then, by 1984, Parliament decided to formally codify this empathy. They replaced that common law duty with the strict statutory duty we use today. All right, Part 3, the three-part duty test. So exactly when does this apply? Section 1, subsection 3 of the Act sets out the precise statutory conditions that have to be met for a duty to be owed to trespassers. And it's actually much narrower than the duty owed to lawful visitors. You really have to treat this like a strict legal checklist. All 3 of these elements absolutely must be satisfied. Step 1. Is the occupier aware of the danger, or do they have reasonable grounds to believe it exists? Step 2. Do they know or have reasonable grounds to believe a trespasser is in the vicinity of that danger? And Step 3. Is the risk one against which it's reasonable to expect the occupier to offer some protection? If you miss even a single one of these steps, the whole thing collapses. No duty is owed. To put that into perspective, let's look at how this checklist plays out in real life. Take the 2004 case of Higgs versus Foster. The occupier had a dangerous inspection pit, but they couldn't possibly anticipate a police officer climbing over their wall at night to conduct surveillance. So they failed Step 2, no reasonable grounds to suspect a trespasser. Or consider Rind versus Asbury Water Park, where someone jumped into a lake and hit a submerged fiberglass container. The occupier had absolutely no idea that container was down there. That feels Step 1. They weren't aware of the danger. In both of these cases, there was simply no duty owed. Period. Which brings us to Part 4, limits and obvious dangers. Now, before we look at the specific case rulings, ask yourself this. If someone knowingly takes a massive, obvious risk on someone else's land, should the landowner really have to foot the bill if things go terribly wrong? Well, the courts are actually very strict about enforcing personal responsibility here. In the 1999 Ratcliff case, a student climbed a fence to dive into a closed college pool at night. The court basically said, look, you don't need a warning that a closed pool is dangerous to dive into without checking the depth. That's an obvious danger. Similarly, in Donoghue versus Folkestone properties, dealing with that midnight winter harbor dive we just talked about, the judges ruled the occupier owed no duty whatsoever. They just wouldn't expect a trespasser to be jumping into the freezing water at that completely unforeseeable time of day and year. The ultimate example of this, though, is Tomlinson versus Congleton Borough Council. An 18-year-old completely ignored warning signs and dived into a shallow lake, breaking his neck. It's tragic, but the House of Lords established a really crucial precedent here. They ruled that the danger wasn't due to the state of the premises itself, but rather his own reckless action of diving. The law simply doesn't require councils to spend absolute fortunes draining lakes or building impenetrable fortresses just to protect trespassers from obvious risks they actively choose to take. Now, here's a detail that might surprise you. The exact same statutory rules apply to child trespassers under the 1984 Act. In the Keown case, an 11-year-old fell while showing off on a hospital fire escape. In Baldacino, a 14-year-old dived off a navigational beacon at the beach. In both of those cases, the courts found zero liability for the occupiers. Why? Because the injuries didn't result from an inherently faulty fire escape or a broken beacon. They resulted from what the youths consciously chose to do with them. Part 5. Defenses for the occupier. So if a claim somehow makes it past those strict tests, what legal shields can the occupier raise? Well, the most absolute shield available is valenti, or consent. This is a complete defense found in Section 1, subsection 6 of the Act. It completely blocks the claim if the occupier can prove the trespasser didn't just know the risk existed, but fully appreciated the exact nature and degree of the risk they were taking and, chose to take it anyway. Occupiers also have a couple of other really powerful tools in their arsenal. They can argue contributory negligence, which basically means if the claimant was partially to blame for their own injury, their final financial payout gets reduced proportionately. And, perhaps most importantly, an occupier can rely on clear warning notices to discharge their duty entirely. Take the Westwood versus Post Office case as a perfect example. A simple notice on a door stating only the authorized attendant is permitted to enter was deemed an entirely sufficient warning. The employee who wandered into the unlocked room anyway was treated as an adult trespasser, and the post office was completely protected from liability because that sign did exactly what it needed to do. Finally, Part 6, the bottom line. The fundamental takeaway from all this is the stark distinction in legal protection between someone who is invited and someone who isn't. A lawful visitor, covered under the older 1957 Act, can claim compensation for both personal injuries and damage to their property. But a trespasser, reflecting their lower status in the eyes of the law, can only ever claim for personal injury. So if a trespasser sneaks in and breaks their leg, but also ruins their expensive smartphone in the process, the smartphone is completely on them, no compensation for the property. Which perfectly leads us to this defining principle from the Tomlinson case: individuals must take responsibility for their own actions. You see, this act originally stepped in to prevent a harsh lack of humanity, but over the decades it has heavily evolved to protect property owners from footing the bill for reckless behavior. So ultimately, does the law overly protect trespassers by giving them a potential claim at all? Or does this powerful emphasis on personal responsibility strike the perfect balance for public safety? Definitely something to think about the next time you see a keep out sign.